Drake's legal team, most of us, listening to Not Like Us, are bots. Welcome back to Allegedly Stephanie. I'm Stephanie, your favorite recovering lawyer, and we are going to discuss the epic crash out of a one Jimmy from Degrassi, Aubrey Graham, Drake, and how he has started not one, but two beginnings of a lawsuit. Important to note that no lawsuits have actually been filed, and instead we have two pre-action motions. So before we discuss what exactly is a pre-action motion and why Aubrey Graham is deciding to continue what is now a one-sided beef where he is most definitely, indubitably losing and bring it to the legal realm, it should be noted that neither of these potential cases have any strong legal basis. That almost rhymed. Interesting also to note that the two pre-action filings, which were filed last Monday, November 25th, were filed in New York State as well as Texas State. A little bit of forum shopping. Forum shopping is when you as a petitioner decide that a judge or jury in a specific court will be more sympathetic to your case. Because why else would you be filing in Texas? And then specifically state Supreme Court, if you are alleging so much harm, you do qualify for the federal court. He's not filing either in federal court currently. Now, what is a pre-action filing? Because we covered a lot of things on this channel, but we've never covered that. A pre-action filing is a type of court document which asks the courts to assist the petitioner with various matters of discovery before a complaint is actually filed. So essentially, in this instance, Drake and his legal team want to ensure that certain evidence is preserved, and they are also essentially digging for more information so that way they can flesh out a proper complaint. Because again, nothing has been filed in court yet. And honestly, it's probably for the best on his end that he has a small window of opportunity to realize not only is he losing in the court of public opinion, this legal case is also a loser. And unfortunately for him, lawyers are happy to take your money, pay the filing fee, and continue on with the case, despite the fact that it's very unlikely that Drake will win either of these two potential lawsuits. You know, there is a small, tiny chance that an actual real friend who does not have a weird case comes around and lets him know that these lawyers are here to take him for a ride. So one of the main questions I've been seeing across social media is people questioning, if you are filing a lawsuit, what exactly is the harm, the damages that Drake is claiming? According to the first petition, which is the petition filed in New York, the payoff petition, we can nickname it, and we'll get into specifically what this petition is alleging. Drake's harm, according to his legal team and paragraph 19 of that petition, streaming and licensing is a zero-sum game. Every time a song, quote unquote, breaks through, it means another artist does not. UMG's choice to saturate the music market with Not Like Us comes at the expense of other artists like Drake. As Drake is petitioner's sole owner and petitioner owns the copyright to Drake's entire catalog, petitioner suffered economic harm as a result of UMG's scheme. Interesting. Interesting for a few reasons. One, because the evidence will reflect in this video that Drake allegedly may have been numerous times in his career a beneficiary of payoff. It needs to be stated very plainly from the beginning of this video, this is not a case of one artist going up against the machine. Drake is not an independent artist that cares about other independent artists. This is not Prince fighting for the people. This is somebody, unfortunately, crashing out because they have been publicly embarrassed and rightfully berated via melody and good beats. Now, for petition 1, who are the petitioners and the respondent? So the petitioner in this case is Frozen Moments LLC, which is one of Drake's company that, according to the petition, he wholly owns. Then you have UMG Recordings, which is distribution for both Drake and Kendrick Lamar, which makes this even more interesting that he's saying his own label is not helping him, and his own label is helping another artist to the detriment of himself, which that doesn't really work because, of course, these distribution labels, these record labels, they have numerous artists. They cannot just have one artist. This argument essentially doesn't make any sense. And then the second respondent, which if a lawsuit is actually filed, would become the defendant, is Spotify. So in what we can call our payola petition, petition number 1, the 3 potential claims are deep sigh. The Racketeer Influence and Corrupt Organizations Act, aka RICO. I would never forgive Fulton County, Georgia for opening up the floodgates of RICO by bringing that foolish RICO rigmarole case against Young Thug, which we have an old video on that, which let me know now that that has wrapped up, which I had stated for the past 2 years that that case was never going to get a guilty verdict and he would likely get a hung jury. They ended up letting him plead out in the end. If you'd like to know why that case was the biggest and longest running Georgia trial, aka Hot Mess Express, we can do a video on that, because that case then allowed the Fulton County DA to weaponize RICO and the RICO statute against others, specifically against protesters that are protesting against Cop City. There are numerous people who have been charged with criminal RICO for simply protesting against Cop City being built in Atlanta, Georgia. Yeah, that's where we're at. What is this, Oprah? You get a RICO, you get a RICO, you get a RICO. This is not what the law was intentioned for. The second potential claim, identify appropriate defendants and frame a complaint under the New York Deceptive Business Act. Potentially, I think there could be a claim there. However, the way this is written and how sloppy this is, I doubt it. And then lastly, third, the New York False Advertising Act. Put a pin in the RICO specifically because we're going to circle back to that. According to Drake's legal team, paragraph 5, UMG did not rely on chance or even ordinary business practices to break through the noise on Spotify and likely other music platforms. It instead launched a campaign to manipulate and saturate the streaming services and airwaves with a song, Not Like Us, in order to make the song go viral, including by using bots and pay-to-play agreements. On information and belief, UMG charged Spotify licensing rates 30% lower than its usual licensing rates for Not Like Us, in exchange for Spotify affirmatively recommending the songs to users who are searching for other related songs and artists. I think before we continue, it is very interesting because according to this article from Billboard a few years ago, Spotify subscribers demand refunds over too much Drake promotion by Colin Stutz. With the release of Drake's latest album, Scorpion, on Friday, Spotify spent the weekend spreading the news of a promotional takeover that might have helped hype up fans, but also turn some off. In that article, it then details how Drake's face was made to be the cover of British music, rap music, hip-hop, jazz, everything to flood Spotify with Drake. It's interesting how when the same tactics are used for other people, then saltiness occurs. Not that I agree with these tactics, just to put that out there. One of the things that Drake's legal team is claiming, specifically that UMG and Spotify colluded, and that's where they're trying to insinuate that maybe a RICO claim could occur. To have a RICO claim, you have to show that there is an organization and that organization is doing illegal activity in furtherance of the enterprise. RICO was essentially and intentionally, ironically enough, and spearheaded by Rudy Giuliani in the 80s, who has his own RICO case, rightfully, to catch the mafia, the cartel, people illegally putting together very covert businesses. None of the elements of RICO are established in this case. One of the things that the pre-action petition is trying to do is they're trying to convince the judge to basically have discovery before actual discovery. So discovery usually happens after you file the complaint. The defendant then files their response. You move forward and you request evidence. This is essentially pre-discovery because what Drake's legal team is saying, oh, we think that some impropriety happened, but we need a little bit of evidence to put it in the complaint. So basically, the pre-action filing is supposed to convince the judge that this mystery evidence exists somewhere and to then allow Drake's legal team to get access to this mystery information. One such mystery information in paragraph 8, I found very interesting. According to Drake's legal team, one individual unknown to petitioner revealed publicly on a popular podcast that Mr. Kendrick Lamar Duckworth's label, i.e. Interscope, paid him via third parties to use bots to achieve 30 million streams on Spotify in the first days of the release of Not Like Us. The whistleblower described Spotify as the easiest platform to bot because it does not, like other streaming platforms, have certain security measures when it comes to bot protection. The whistleblower further revealed that on May 6, 2024, an individual affiliated with Interscope sent him a payment of $2,500 and that he was promised another $2,500 and a percentage of the song's total sales for this initial push. A very low sum of money to allegedly commit crime and allegedly be able to push bots into the Spotify system. I'm not buying it. Had they said $50K? Maybe. Every other instance of payola that we've covered on this channel, even the most basic payola that has existed in the music industry for decades, which is radio play, it's usually around 20 to 40 grand. 50 grand. $2,500 in this economy? I'm not buying it. On information and belief, UMG hired other unknown third parties to use bots to promote Not Like Us and also to inflate the streams of Not Like Us music video, which UMG first published on July 4th, 2024. Publishing the music video to Not Like Us on July 4th, America's fake Independence Day, after you called the Peak by Rascal a colonizer and not a colleague? That is my level of petty behavior. I would like to know, it is personally inflammatory to me as I have watched the video to Not Like Us at least 3 dozen times whilst on the Stairmaster to call me a bot again. Very rude. Which, by saying that the views on YouTube are also inflated, they're essentially stating that YouTube views can be inflated. Which, if so, I really need to pay off my student loan, so, run it up. So, as referenced in the Billboard article, not only has Drake been the beneficiary, allegedly, of payola at varying times, it is an industry issue that needs to widely be addressed. I know Sabrina Carpenter's Espresso is very catchy. However, why is that playing after people are listening to Azalea Banks? Those things don't go together. Now, to further their claim of payola, paragraph 11 states, UMG engage in similar pay-to-play schemes to increase the airplay of Not Like Us on the radio. Petitioner has obtained information from a third party indicating that at least one UMG employee made payments to an independent radio promoter serving as an intermediary who had agreed to transfer those payments to certain radio stations and our radio station employees. This practice, known as payola, is prohibited by the Communications Act of 1934 and has been the subject of regulatory scrutiny by a number of executive agencies. Payola unfortunately runs rampant, and people that it affects the most are independent music artists, not Drake, who, whilst, is a very talented and problematic man. I was going to say young man, but the age is catching him. He is not and hasn't been ever an independent music artist. If anything, his team trying to frame this as him fighting against the machine and him fighting against the mainstream is proving Kendrick's point that he is indeed the mainstream. The petition goes on to further claim, as part of its deal with UMG, the NFR podcast published podcast episodes, tweets, and other content publicly about the song. And in a sea change for UMG's internal policy, UMG removed the song's copyright restrictions on YouTube and Twitch, thereby whitelisting the song for the first time in UMG history, which further incentivized influencers to spread the song. Essentially, they are claiming that UMG capitalized on the popularity of the song. They didn't realize the song and this rap beef in general would be so popular. That in and of itself is not illegal. One of the interesting things to note in both of these petitions, neither of the respondents, who will become later defendants if a lawsuit actually gets fired, none of them are Mr. Duckworth. Mr. Duckworth, aka Kendrick Lamar. I love that a lot of our favorite musicians have very good, strong civil rights names. Kendrick Lamar Duckworth. Plies, which we did a live stream on a couple months ago, also has a very strong civil rights name as well. Hopefully, that leads into some more activism. So according to the petition, over the past several months, Drake has repeatedly sought to engage UMG in discussions to resolve the ongoing harm he has suffered as a result of UMG's actions, which at the beginning of the petition, they state that the harm, what he's suing for, is basically not receiving as much promotion as Kendrick Lamar for this multiple songs that they both made for their mutual rap beef. I mean, one set of songs was better than the other set. Again, my favorite line, how are you going to come back from being called not a colleague, but a colonizer after an entire needed history lesson? Interestingly enough, in the petition, according to Drake's legal team, UMG refused to engage in negotiations with Drake and insisted that UMG is not responsible for its own actions. Instead, UMG has pointed the finger at Mr. Duckworth, insisted that Drake should initiate legal action against Mr. Duckworth rather than UMG, and even threatened to bring its own legal claim, allegedly, against Mr. Duckworth if Drake were to pursue claims against UMG. I highly doubt the last point that they're making is true. Because again, both of these artists are clients of UMG. It's like watching two of your siblings fight and you're just like, well, I tried to reason with y'all should have let it go, and here we are. The second petition is basically stating that Drake and his legal team would like to sue for defamation. Defamation against iHeartMedia and UMG Recordings, Inc. Again, Mr. Duckworth is not mentioned. However, this is fascinating. Let's read what exactly Drake and his legal team feel is defamatory language. By falsely accusing him of being a sex offender, engaging in pedophilic acts, harboring sex offenders, and committing other criminal sexual acts. Specifically, the song called Drake a certified pedophile, a predator, and someone whose name should be registered and placed on Neighborhood Watch. If you are so discouraged, upset that people are calling you these things, what do you think this pre-action filing and a potential lawsuit is going to do besides remind people that your colleague, who is not a colonizer, called you these things? To sue UMG, stating that UMG as the label was in control of what Kendrick, who writes his own music, decided to write down, is such an interesting way to go about defamation before we get into the defenses against defamation. This is something that we haven't seen done in this way and is still going to fail. So, according to paragraph 4 of the second petition, UMG has exclusive control over the licensing of Not Like Us and could have refused to release or distribute the song or required the offending material to be edited or removed. But UMG chose to do the opposite. UMG designed, financed, and then executed a plan to turn Not Like Us into a viral mega hit with the intent of using the spectacle of harm to Drake and his businesses to drive consumer hysteria and, of course, massive revenues. That plan succeeded, likely beyond UMG's wildest expectations. Whether you are new to watching my channel or if you have been here from the beginning, we've covered defamation on here numerous times, and I know that you know an absolute defense to defamation is what? The truth. The truth in question is, did Drake at his big age of 32 invite a 14-year-old Millie Bobby Brown to his concert and then initiate a friendship with said 14-year-old? Is there or is there not evidence that, again, Drake in his big age of 32 texted a 14-year-old Millie Bobby Brown, "I miss you so much"? If Drake was on the stand and we were asking him these questions, were you or were you not at your, let me check my notes, big age of 38, pursuing a relationship with Lotto's 21-year-old sister? Does Baca not have a weird case? As illustrated from the Toronto Sun, Drake entourage member guilty of assaulting woman, published May 12, 2015, to which he pled guilty at the big age of 37 and was sentenced to 6 months in jail for assaulting a 22-year-old young woman whom claimed that he was trying to sell her into prostitution. Is this or is this not you in 2022, April 8th, sitting next to the said Baca in question? In a now deleted Instagram post, when Baca was released from prison, did you or did you not throw that man a party and state that you were so excited and had waited so long for him to get out of prison for, again, pleading guilty to assaulting a 22-year-old when he was 37? I'm sure there's more. Interestingly enough, if we put that aside, proving defamation against a public figure is extremely hard because you have to show two things. One, maliciousness, which Kendrick did say, I hate the way you talk, the way you walk, the way you dress. I mean, the hatred is visceral. It's there. However, you have to show maliciousness and that you knew what you were saying against said public figure was a lie. And that when you knew it was a lie, you went forward and published all the defamatory things. As we have already stated, we don't know that it's a lie. There are enough people coming forward that it is strange that a 38-year-old man does prefer, it seems, to speak to very young women. And before you catch yourself defending that, you need to sit with why you don't think it's weird. The third reason really, why this defamation claim will definitely fail if he decides to waste his, I would say, objectively hard-earned money on this case would be because this exchange of words that he is so upset about that he allowed to be published, and again, he has listed it out in paragraph 3. Specifically, the song calls Drake a certified pedophile, a predator, and someone whose name should be registered and placed on Neighborhood Watch. They should have included the A minor in there because that play on words, diabolical. This will fail because this exchange of words was exchanged during a mutual rap battle to which Drake also said hyperbolic, hurtful things to one Kendrick Lamar Duckworth. Neither a judge nor a jury is going to find the high bar of defamation is met when the two of them are going back and forth with each other a la soap opera for about a week and a half. It's not going to happen. It would set a precedent that is nonsensical. And also, it brings me to the last thing that I want to talk about, which has nothing to do with the law and more the court of public opinion. Weaponizing your proximity to whiteness is peak by rascal behavior. All Drake and his team had to do was hush and eat their food in the corner. People would have gotten over it. Should they have gotten over it? Debatable. That would get into my personal preferences. However, people are fickle. They would have gotten over it. This case is basically now memorializing his epic loss, not only in the court of public opinion, but in the literal court. While this is a pre-action filing, it has been filed and will remain on file in the court forever. 10, 20, 30, maybe 100 years from now, if this country lasts, a random law student can go and search this up and be like, wow, there was an argument between these two musicians and one really went for the jugular. And instead of being quiet and, coming up with a good beat and moving on from it, the other one fully crashed the hell out. For the people that, want to still see the goodness in Aubrey Graham, it should be noted that he is not going against the mainstream to benefit the little guy, which is the independent music artists who are often screwed by the streaming companies like Spotify. He is doing it because he's simply a sore loser. This will not change how Spotify interacts with distribution companies / record labels. This is not going to do anything for the independent artist that is making barely pennies on their streams. To note before I say this video is not sponsored. People are rightfully complaining that Spotify has essentially overstepped the trust with the consumer of, hey, this is my playlist. These are the types of songs that should go together by putting Not Like Us after country music or putting Sabrina Carpenter's Espresso after heavy metal. This and the fact that I'm just a creature of habit is why I stick with Pandora. Pandora's algorithm is too close to obsolescence for any record label to care about paying payola to actually influence what is coming up next. Pandora has yet to lead me astray, and yes, that app still works. Now, if I ever log myself out, will I be able to log myself back in? No, because it's attached to my college email, which has been defunct for a decade. But that's neither here nor there, and hopefully will not become my problem anytime soon. I think it'll be interesting to see how Drake's PR team spins this, because if Sense is ever going to find him, we will not hear about these potential lawsuits becoming lawsuits again. If he actually files this, I would say that he's going down a path that I'm not sure that anyone can recover from. Because if he were to actually file this, UMG, iHeartMedia, and Spotify are going to do what I did, which is a quick search, but even a deeper dive into who exactly he's been talking to all these years. On that note, I appreciate y'all. Shout out to Patreon for keeping the lights on over here. And if there are any other specific cases you'd like us to discuss, let me know in the comments. It's times like this I really do miss the wine, though. So maybe I'll bring it back.